Assalamu alaikum and good afternoon. I think the subject on which this panel is here to dilate upon is that what are those rules which are associated with the arbitration. ADR practice and procedures are global in nature. Pakistan needs to intertwine itself with these and promote the attainment of such qualifications to improve the capability and the capacity of the arbitration and ADR practice act. So this is what the apparent theme of this panel is. But there is also an undeclared theme, which is that arbitrate and not litigate actually. So in Pakistan, currently we are having two different laws dealing with the foreign and domestic arbitration. One is an Arbitration Act 1940 and the other is Recognition of Foreign Arbitral Awards Act 2011. So to start with both these, there is an underlying principle, which is that none of these statutes, they actually oust the jurisdiction of our courts. The courts still retain the jurisdiction to deal with the matter. There are two issues coming today. One is a situation before an award and the other one is a post-award situation. So let's dissect the foreign award and the domestic award. We have very aggressive, proactive enforcement with regard to foreign arbitration awards after the promulgation of this Act of 2011. However, the main problem is the domestic arbitration, because the law dealing with the domestic arbitration actually provides a lot of room for interference to the court before, at pre-arbitration stage and post-award stage. So for instance, that our courts are entitled to interfere in the matter of appointment and removal of an arbitrator. The court can actually revisit the award in exercise of powers, because unless the court passes a decree on the award would never become a enforceable document. So actually our courts have the power also to modify a domestic award. So the problem is that once an award has been made by an arbitrator, it again goes to the court, where almost a full trial is conducted of the case and then a decree is passed on that. And the time consumed in the entire process is minimum 5 to 6 years. So my focus today is that how to deal with this problem that should encourage the domestic award to be effective and enforceable expeditiously. So my experience is that unless we amend the Arbitration Act 1940 and actually create an environment where courts are actually supportive of an arbitral process, which the basic criterion that why courts, speaking from my experience, why the courts are not comfortable with referring the matter to an arbitrator, for the reason that we don't have a forum available which enjoys actually a credibility, capacity, capability to deal with the problem. So this perhaps is the biggest problem currently faced by the courts. And then the other issue is that the courts in Pakistan, they are jealously guiding their own jurisdictions. So convincing a court to refer the matter to an arbitration, and that too in the domestic cases, perhaps it's little difficult, because the court, before staying the matter or referring it to arbiter, carried out a full appraisal of the case. So what actually has to deal with this is that how to deal with this scenario, and after all the speakers we will conclude that what actually is a way forward.